Thank you very much for joining us today for our presentation on the E-2 visa. Today we're going to be talking about some of the most common questions that we receive about the E-2 visa, which actually is, I would say, the most common visa that our firm handles, and for very good reason. Our firm was actually founded by Ian Scott on an E-2 visa, and he currently has an E-2 visa. So the firm was founded over a decade ago. And Ian's experience navigating that process, applying for the E-2, as well as several visas before that, really does inform the way that we work with our clients and have a very client-centered approach to everything we do. So my name is Dustin Saldariaga. I am a senior associate at Scott Legal PC, and a few things to go over before we get started and begin our discussion with Ian. Even though our firm does focus on business immigration, we handle the full spectrum of U.S. immigration cases. So whether that's family immigration, temporary visas, green cards, humanitarian visa options, whatever it is, we hope you won't hesitate to reach out if we can be helpful at all. It's very easy to schedule a 30-minute consultation on our website, so we hope you'll do that if you have the need. We will be continuing this webinar series. We do at least 2 webinars a month, and typically many more than that. The webinars cover a variety of topics. So after this presentation, you'll be getting an email where you can sign up for our future webinars, and we do hope to see you all on those future webinars as well. In that email, you'll also receive our comprehensive E-2 visa guide, as well as a link to our YouTube channel. On our YouTube channel, we post many videos, again, on a variety of immigration topics. Some of them are shorter. Some of them are the full-length webinars, such as the one you're watching now. So this webinar is being recorded. It will be posted to our YouTube channel. We really do try to make our YouTube channel a great resource, of course, for free. So do take the time to check that out if you have any questions at all and want to learn about the visa options that our firm handles. There will also be a link in that email where you can schedule a consultation. As I mentioned, we're very fortunate to have Ian Scott with us today. Ian is our firm's founder, and he has extensive experience navigating the E-2 visa process, both on behalf of clients and personally. If you have questions at any point during the presentation, send them in through the Q&A function on Zoom or through the chat function. I will be monitoring both. So without further delay, let's go ahead and dive into our questions. Ian, would you mind telling us what is an E-2 visa and who is the ideal E-2 visa applicant?
Sure, absolutely. Thank you very much, Dustin. And I think that, I could answer that question by describing my own situation or my own case where I decided that I wanted to set up a business, and I made an investment in that business. I kind of purchased everything that was required to get that business up and running, that business being the law firm Scott Legal, and developed a business plan and said that described how I was going to hire employees over time, and then was given the visa. So I think that who the visa is for people that are entrepreneurs and who want to start or buy a business in the United States and do have some investment to be able to do that. I think the other kind of key thing with respect to the, who can apply for this visa is really the visa is based on a treaty between the United States and a number of different countries, approximately 80 countries around the world. And those countries are spread over all continents except for Antarctica, so there are many places that countries that are eligible for an E-2 visa, but you do have to be a national of one of those countries, and that means having a passport from the country. The country of birth is not important, but having an actual passport from that country is what determines your kind of maybe a threshold issue with respect to eligibility for the E-2 visa. So two of the world's most populous countries, China and India, unfortunately are not on the E-2 visa list, but again, many other countries are.
Great. And so you touched on the nationality requirement, the requirement that you have citizenship in a treaty country. What are the other key requirements for an E2 visa?
Sure thing, sure. So the I'd say that, kind of two main requirements for an E2 visa. So one is investment, right? So one is that you are taking, your personal funds and investing in a business, and that can be purchasing a business or investing in a startup. And the investment also requires that you spend money, right? So the government is not interested in the idea that you are planning on starting a business, or if you have money just sitting idle in a bank account, that won't qualify for an E2 visa. But you actually do have to, if you're purchasing a business, you actually have to have purchased the business, like sent the money to the seller or put it in escrow. And if you're starting a business, you have to have put the money in a business bank account and spent everything that's required to get the actual business up and running. So there's the kind of spending requirement is one key requirement, and then there's some add-ons to that requirement, because if you're spending everything to get the business up and running, that means that the business is really close to operational, right? Like if you have a lease already, you have a website already, you may have employees already, you have whatever licenses are required to operate the business already. But we'll lump all of those with the initial investment. And the other significant part of an E2 visa is that you plan to hire US workers. So that this can be accomplished by you don't have to have the employees on day one. If you're purchasing a business, the business should be a business that has employees. And if it doesn't have employees, you want to be able to show that you're able to hire employees over time. But the employees are another key piece. If you're starting a business, then you're going to be able to support this requirement by showing a comprehensive business plan. You may also want to show the government that you have prospects, right? So it might be that you show them that you have contracts of people who are interested in your services, or you have letters of intent or some other proof. And then another great form of evidence is if you already have employees, right? Showing the government that you actually have already hired employees. If you purchase a business, that the business already has employees. But there's some other ancillary requirements, but these are the two key, two key aspects of an E2 visa: the investment and job creation.
Perfect. And we will be talking more about that investment requirement. For now, I want to go back to the nationality requirement you mentioned before. If you said that two of the most populous countries in the world, India and China, are not E2 treaty countries, um, can someone from India or China or from a country that's not an E2 treaty country get an E2 visa?
Sure, they can, but the rules recently changed with respect to the timing. So in the past, before I can't recall exactly when the rule changed, but relatively recently, within the last year, in the past, an individual from China or India could purchase citizenship from a country that was a treaty country. Like, so for example, Grenada is a great example. For I think as low as $250,000, you can get a passport from Grenada. There are other examples like Turkey and other examples as well where this was possible. So a passport through investment. Now, what nationals that weren't nationals from treaty countries did was they obtained these passports, and then they applied for an E2 visa, and they were successful. That was not a problem at all. But then the rules recently changed, and now what the rules say is that in order to obtain the visa, you have to have resided. So not only do you have to have the passport, but you also have to have resided in that particular country for a number of years. I believe it's 2 years. It's either 2 or 3 years, but I believe it's 2 years. But so now, in order for that person to be able to get the E2 visa, they'd not only have to pay the 250,000, but they'd actually have to move to the country and reside there for a number of years. So it is possible, but it's just going to be a much more time-consuming endeavor.
Perfect. And then once you receive the visa, how long does the visa last for?
Sure. So the visa length is going to depend on a few different things. So the primary determination of the visa length is going to be which country you're from, because when the countries sign a treaty with the United States, the United States will determine how long the visa can be issued for. So that can range from either 3 months to 5 years. So if you're from Canada, if it's going to be 5 years. If you're from the United Kingdom, it's going to be 5 years. If you're from France, it's going to be, I believe, 24 months. If you're from Bangladesh, it's going to be 3 months. And if you're from there are a number of other, Egypt, I think, as well, as 3 months. So what the timing, though, means is how long the visa can be issued for. And the visa is an entry document only. So even the instances where the visa is only issued for 3 months, what that means is that the individual can enter the United States within that 3-month period. And every time they enter, they're allowed to stay in the United States for 2 years and operate their business. But what would happen is if they left the United States and re-entered, they would have to have a new visa in their passport. So that's one determination of what governs the time. It's called a reciprocity table. So which country that it is you're from. So if someone, for example, had two passports, like let's say someone had a passport from France and had a passport from Canada as well, if they were applying for an E-2 visa, they would be much better off using the passport from Canada because it could be issued for 5 years as opposed to 24 months. So that's something to keep in mind. Another factor that determines how long the visa is going to be issued for is going to be the consulates that is issuing the visa. And sometimes there are consulates that, even though someone might have the ability to have the visa issued for 5 years, a consular officer may say, well, the case is not that strong. So we're going to, instead of issuing it for 5 years, we're going to issue it maybe for 2 or 3 years, and then make the person come back after that 2 or 3 years and show us that the business is still viable and they have actually been able to hire U.S. workers. So those are really, I think, the kind of two factors that determine the length of time that a visa can be issued for.
Great. One of the key requirements you talked about before is the investment requirement. And one of the most common questions we get is how much investment is needed for an E-2 visa? So I'm curious what your response to that question is.
Yes, exactly. And that definitely is, without a doubt, probably the most common question that we get. And I try to, kind of dissuade people from trying to extract just a particular number, right? Like to say, okay, well, this is the number. What will say to clients is that we believe that you should spend at least X, right? So spend at least $50,000, $60,000 to get the business, as a minimum, just as a minimum. Now, like when we talk about amounts, we have processed E-2 visas with as little as $15,000 spent, right? But the problem is that when the investment amount is very low, even if it's a business that does not take a significant amount of investment to get up and running, like a service-oriented business, like my business, for example, there still is a requirement to spend money. And the government is not, I don't think I've seen an E-2 visa application approved with less than $15,000 spent. And if you do spend such a low amount, like under $50,000, $60,000, the application is a riskier application. And risk means risk of denial, right? Denial because it's a low investment amount, right? So the government's not as receptive to the idea of lower investment amounts, and in particular, certain consulates will really reject low investment amounts, regardless of the type of business. But when you're deciding on exactly how much that investment amount should be, you're going to take a look at the actual business that you're getting set up. And you have to ask the question of how much does it take to get this business up and running? And if it's a service-oriented business, then certainly that's going to be a lower number. So maybe we can deal in the lower investment amounts, the 50, 60,000 or so that we talked about, or even lower if you have other factors, as we'll talk about in a second. But if you're starting, for example, a grocery store or a car dealership or something, then the investment amount could be in the hundreds of thousands of dollars in order to get the business up and running, because the government doesn't have a specific investment amount like they do with some other visas, like the EB-5. There's a specific number. Instead, they say the investment must be substantial, and then they leave it up to the type of business that one is trying to set up. Now, the other kind of factor and this is the reason I encourage people not to focus just on a particular number. The other kind of factor that we look at is really, where is the person applying, right? Which consulate are they applying at? Because, even though the U.S. government rules are, there's only one set of rules, but different consulates will adjudicate E-2 visas differently. And there are some consulates that If your investment is under 100,000, you may as well not bother showing up. They might laugh you right out of the consulate, or But whereas there are other consulates that are quite, can will really accommodate lower investment amounts and without problem. Similarly, if someone's applying through USCIS, we've seen very, very low investment amounts through USCIS because they are looking more holistically, I think, at what it costs to get the business up and running, and do have maybe a little bit more recognition that it doesn't take a significant investment to get a business like a service-oriented business up and running. The final thing with investment amount to consider with respect to how much to invest is what are the other factors of the case that and really strength factors, or even weakness factors. If the case is weak, you should spend more, as much as you can. But if the case is a strong case, so for example, let's say the company already has employees, or I recall a case that we did where the investment was around the $20,000 mark, but it was in essence a doctor's office, and the person already had, and they were treating a particular disorder, and the person already had kind of government contracts that were really amounted to in the millions of dollars, and it was very easy for a consular officer to see that, oh well, doctors' offices, they're usually not just one person. They usually employ a number of people. And that person was approved, no problem. And just as a side note, that person went on to marry a U.S. citizen, and also then went on to become a citizen. And we processed all of those applications for the applicant, and they sponsored their parents for a green card as well when they became when they became a U.S. Citizen. So, the investment amount, really, it's important to look at it holistically, and work with a good immigration lawyer to kind of decide, well, what is a good amount? Like, we understand that people are very quick to desire, as low as possible, but as low as possible won't necessarily get you the visa. When I was doing my case, I signed up for a 1 year irrevocable lease where I was paying $1,700 a month for the lease, and I didn't need a lease at all. I was just myself. I didn't need an office. It was completely unnecessary, but it was 20 grand later, right? Because I had to pay that for the entire year, even though I barely used the office. I was able to get the visa, right? So I was able to, in the actual investment amount, I only included the amount I paid the first month and last month, but even that was $3,400. So it significantly increased the amount of my investment. So the investment amount, we understand that people want to keep it as low as possible, but the success rate of a case definitely improves if you spend more money. So.
Perfect. And can you say a little bit more about what you're actually spending money on? What are good expenditures and what are weak expenditures?
Sure, absolutely. So the definitely all expenditures are not created equal. So you definitely want to look at things that an officer is going to look at as valid expenditures that are really necessary for getting the business up and running, and they have in their mind what they feel are valid expenditures, and we've taken note of them over the years. So things like money that you spend on employees, money that you spend on marketing, money that you spend on your website, money that you spend on an office lease, money that you spend on furniture or equipment. All of those things are good E-2 visa expenditures, as opposed to things like money that you spend on travel to get your business set up, money that you spend on food or entertainment. Money that you spend on any type of training course, training or education related to the business. Also, a car can go either way. A car can be a very valid E-2 visa expenditure if it's a business that actually requires a car. Like if you're doing we have some clients that have done maid service businesses and cleaning businesses, and that certainly necessitated a car, van, and they'd even brand the car. So that was very useful. But then if you're running a consulting business, even the IRS probably would give you a hard time deducting anything for a car. So it's not really an officer might see a car as a, for a consulting business, like for example, my business, they might see it as a personal expense, right? And not really a business expense. And similarly with rent, including rent for residential property is not a good idea for E-2 visa expenditures.
Great. And a moment ago, you were talking about strong versus weak cases. Can you say a little bit more? You were referencing employment in terms of saying, you use that as an example of a stronger case. Could you say a little bit more about how when you look at a case, what is a stronger case versus a weaker case? What are you looking for? And
Sure.
then when you have a weaker case, what are some strategies to deal with that?
Sure, absolutely. So I'd say that the stronger cases are cases that have higher investment amount and real indications of ability to hire U.S. workers. I think those are stronger cases. The other kind of things that make a case a stronger case is the government likes franchises, right? That's that's that automatically moves you into a stronger stronger case. And then I think that there's some types of businesses that are the government is inherently suspect of, like real estate businesses or equity trading and things like that. So those ones can be difficult. And I think that in terms of strategies to improve kind of weaker cases is to just address those particular issues. So if it is an amount, kind of spending amount, not only spending amount, but spending on expenditures that we've you know classified as good expenditures, but then also looking at some of those other factors that we talked about that are strengthening the case, which are hiring employees or getting contracts. The other kind of thing that can strengthen an E2 case, when we don't typically submit this in the first instance, but it can strengthen an E2 case if you're either applying at a consulate that's not very used to E2 visas, or you get a question, or if you're denied because of low investment amount, is getting a CPA to write a letter that describes that you've spent everything that's required to get this particular business up and running. So that can be very helpful. But yeah, so those are some strategies too. And then definitely working with a lawyer. And I know that sounds self-serving, but it is interesting how many kind of times we see people who have been denied and then they come to us and it's like, oh wow, like this was submitted because they were absolutely ineligible at the time that they applied, but then didn't even really know it. So yeah.
That's helpful. And you mentioned employment. Just to clarify, do you need employees? Do you need to have employees before you apply for an E2 visa?
You don't. It's definitely not required to have employees on day one. It can be helpful for an E2 visa application to have employees on day one, but it's not required. It's not required. So as long as you have a robust business plan and indications that you are going to be able to hire U.S. workers, that can be sufficient for the initial application.
You mentioned before how a franchise can be make for a stronger application. What about buying a business, and specifically buying a business from a relative? Is that an option? And if so, what are the risks involved there?
Yeah, so buying a business is also an excellent E2 option. Consulates love that. If you have an existing business where you can show tax returns that show that the business has had employees over at least the last year, and the business is successful, so has some profit, then that's an excellent E2 visa choice as well. Right, so that is that it kind of puts you on some of the things that you have to prove subjectively are proved objectively with buying a business, because you're showing objective information related to employment versus a business plan which says, oh well, I plan on creating employment, and the officer has to make the determination of whether or not you're going to be successful doing that. So Buying a business is great. I think buying a business from a relative can be inherently problematic. So we do see issues at consulates where the consular officer does not believe that there actually has been a real transaction that has occurred between the relatives. And the one, unfortunate thing with E-2 visas is consular officers do not have to provide a detailed explanation with respect to why it is they're denying a particular case. They can close the window and just say kind of go away. So I think that it's one of those things that putting your best foot forward is definitely better. And if you are going to purchase a business from a relative, then probably get a valuation of the business, and so you can kind of say, well, yeah, this is, I'm paying X number of dollars, and this is how much the business is worth. So it is perhaps providing a little bit more legitimacy to the transaction, because we have seen issues with that. Even in one case where the relative purchased a business from her brother-in-law, and we warned them that this could be an issue, and they went to the consulate and it was actually approved. And it wasn't until they went back to the consulate 4 years later that the consular officer looked at the case and he said, this should never have been approved in the beginning. Like they said the person got the money from the mother gave the money to her daughter, the daughter gave the money to her brother-in-law, which is in essence giving it to her sister as well. Like, it was all a family. This is just money circulating around the family. And the person, our applicant, the applicant was buying 50% of the business. So they weren't even buying the whole thing, they're buying 50% of the business. So the consular officer on the renewal denied the application, said that it never should have been approved in the first place. So it can even come back later, even though it's approved maybe once or something like that. It can even come back to haunt you a little later. So you do have to have your ducks in a row if you were going to take that route.
Absolutely. And I'll take this opportunity to just encourage and remind those of you in our audience, please don't hesitate to send in any questions you have. I am monitoring those and sharing them with Ian as they come in. So please do share any questions you have. So Ian, you've talked quite a bit about the investment requirement. Kind of a related aspect of the investment requirement is the source of funds requirement, how you have to explain where you got this money that you're investing in the business. Can you say just a little bit about the source of funds requirement, and then the specific question is, can you use a loan or a gift as the
Sure.
source of funds?
Sure, absolutely. So the regulations do say that you have to show that the money came from a legitimate source. Now, I will say that when we go to a consulate, this is not something that we focus on. We get a general explanation from the client of where the money came from, and then we may include, usually consulates have page limits, and we may include, a few pages of documentation and just, indicate to the client that they should be able to explain where the money came from to a consular officer if they ask about that. It's not something that consular officers focus on extensively. That this could vary by country. If the country that the money came from is a company that the U.S. government believes experiences, a fair amount of corruption, then that there could be more scrutiny with respect to the source of funds. But generally speaking, we're not going to so if someone obtained the source, the information, if someone obtained the money from saving over 3 years, we may include the first couple of pages of maybe tax returns for 2 years, and that's it, right? And just say that's where the money came from. We're not going to do as detailed a tracing and to show that the funds accumulated over time. And it's definitely not this EB-5 analysis that we would do. Now that does change for very few consulates and then USCIS. So some consulates don't have a page limit, right? So sometimes we may have to kind of bolster the information that we include. And then if we are applying through USCIS is they're extremely exacting with respect to the source of funds. And we do have to actually include, like in that example that I gave you, we couldn't just include tax returns. We would have to include tax returns. We would have to include bank statements actually showing the accumulation of funds over time. So it would be quite a bit of bank statements that we'd have to include. to show that the person was able to save that money over time and actually trace the funds through from inception through to the time that they were transferred over to the business. So it is a lot more complicated when we're doing an USCIS filing. But we wouldn't, that type of analysis or review we wouldn't do for a consular file, because it's just not required normally. Normally they're going to ask, like someone goes into the U.S. consulate in Toronto and it's where did the money come from? Yeah, I was saving the money over time, and I think there are tax returns in the file, and that's usually going to be sufficient for a consular officer. It's not something that they typically get too hung up on. Regarding the question of loan or gift, both loans. So let's do gift first. Is no problem, right? So you can get a gift from anyone. You just have a gift letter, and that's not going to be a problem. Loans are fine. Unsecured loan is completely fine. A loan secured against your personal assets is completely fine. The only loans that can be problematic are loans where the business assets are security. So it's not that they're prohibited, but if that's the case, then the amount can't be included in the investment. And so that could have ramifications with respect to whether or not your investment is considered significant. So that's something to keep in mind.
A great question has come in about the scope of what you can do on an E-2. And specifically, the question is, can an E-2 visa holder expand or change their business after getting approved? For example, can they buy, if they have an E-2 business, can they then buy a franchise that offers a related service? Or would they have to reapply in order to buy a separate franchise, for example?
Yeah, no, it is a great question. So let's talk about that because it's a great question that has a relatively long explanation. So let's talk about that. So when you come to the United States and you have an E-2 visa, you're permitted to work at the E-2 business and perform tasks at the E-2 business and be an employee of the E-2 business. That's all permitted. Now, let's say that you wanted to you were running an E2 business and then you wanted to start another franchise. There are kind of a couple ways you could do that, right? You could start another franchise or a franchise. There are a couple ways you could do that. You could open up a new legal entity and that have that be the franchise. Or you could say, okay, I'm going to have the franchise within my current legal entity. And the two of those have different ramifications, right? So if you open up a new legal entity, you always have to keep in mind that E2 visas are very entity specific. So if you open up a new legal entity, then it might be possible to say that, okay, there's a service agreement between the new legal entity and the E2 entity. So any work you're doing for the new legal entity is really work for the E2 entity. And that could work. And it can especially work if the two businesses are similar, right? So that's kind of one way that you can deal with it. But the other way is if it's a franchise and it's just under your own E2 entity, if there's any way you can argue that it's similar to what you were doing before, and I mean like you can be really take a really broad and general look at this, like if you can say that it's similar, like we had one case where the person had a pool cleaning business and they changed the business to a garbage cleaning, and we said it was all cleaning, and USCIS agreed with us that it wasn't a significant change, right? So if there's any way that you can say that it's in relation to the current business, then you really wouldn't have to do anything. And then the other thing to consider is that if it's just an add-on, if you like in that example where the person was doing a pool cleaning business and then changed it to a garbage cleaning business, they completely stopped the pool cleaning business and they actually sold off the assets of that portion and then did the garbage cleaning business. And that still wasn't considered a change. But let's say they continued running the pool cleaning business. Then I think there would be no question at all that has to even be asked, because they're still doing the E2 business and all they're doing is adding on ancillary services. I'm on an E2 visa. If I decided I wanted to, E2 visa was based on me providing legal services. Let's say it was just in the area of immigration is all I said when I did my application. I think I said more, but let's just, for the purposes of this example, let's say that that's all I said. But now let's say I wanted to offer CPA consulting as well, because I'm a CPA as well. I don't feel I'd have to go back to USCIS or the government and ask them to modify my E2. I would be able to do that under the same legal entity. And again, if I wanted to set up a new legal entity, I would be able to do that, but I wouldn't be able to work for the new legal entity. I would have to do some type of an agreement between my E2 entity and the new entity. And the final variation on this is that you can get two E2 visas. We had one individual, he had a car wash business, and then he wanted to open a pub, and he wanted them under different legal entities for legal and tax reasons, and he wanted to get separate E-2 visas for each of them because he was considering selling the car wash business. Because if he didn't have separate E-2 visas and he sold the car wash business, he would be, he wouldn't have an E-2 visa. Like if he did the arrangement, for example, where he did the operating the service agreement and things like that. So what we did is when we went to do his renewal, we introduced the new entity and said that he's applying for two E-2 visas. So in his passport, he has his E-2 visa, and it says both. It lists both companies. So on my passport, it says E-2 visa Scott Legal, but in his passport it said E-2 visa, the name of the first company, and then the name of the second company. So there are kind of lots of ways, I think, to accomplish your goals, and I think that it's just a good to work with people who understand that there are ways to accomplish those goals, so that you can kind of structure things in a way that's beneficial to you.
Perfect. A great question, and yeah, there's clearly some complexity involved there, but great question, and please continue to send those in. So Ian, can you talk a little bit about, we talked about how a low investment amount can contribute to an application being risky if there's doubt about whether the business will employ US workers, also contributing to risk. Are there any innately risky business types,
Mhm.
that you see people trying to start in the US that just because of the nature of the business, it creates some risk of denial?
Yeah, absolutely. And I think there are two that come to mind. One is businesses that are based on real estate. So could be house flipping, it could be property management companies, it could be even a real estate brokerage. And we've done all of these. We've done E-2s for all of those examples. But they are inherently riskier because the government kind of looks at them and automatically thinks that they perhaps are inherently passive. Right. So we've had questions from people. Oh, if I'm on an E-2 visa and I buy a house and then rent it out, am I allowed to do that? And well, you're absolutely allowed to do that, right? It's a passive form of income. It's like buying stock in the stock market. It's not work. It's not, it's one house. It's not work. The problem is that when someone wants to do now, now let's change the question. I want to buy a house and rent it out. Can I get an E-2 visa? Well, the answer to that is no, because it is for the same reason. It's passive. So in order to do it though, we've done property management companies or people who are buying houses or flipping them and doing things. And in order to do it, we need the person needs more houses, right? Like so, it actually has to be a business such that. The business is going to hire U.S. workers to kind of get over that inherently passive aspect. Now, the other kind of the other kind of aspect or part of that has to do with the the equity trading companies, and so those are those two can be problematic for really the same reason, that the government feels that they are passive in nature, and that is in particular the case if the individual is trading their on behalf of their own they're trading their own money, right, or the money of their or the money, I'm just going to close this door, or the money of the of their family, right? So those are both those both can be problematic because the government doesn't really see them as as real businesses, and that the person's just trading on behalf of their own account. The other kind of issue with those types of companies is that they do require a significant amount of regulation. So, like if someone, we've done hedge funds and things like that, and they do require a significant amount of regulation. So that's something that has to be kept in mind in terms of, making sure that you're meeting all the regulatory compliance. Because in order to get an E-2 visa, that is part of it, because the business has to be real and operating. So you do have to show that you're meeting all of the regulatory compliance elements.
Great. And the another area of businesses that I think raises a lot of questions more because it doesn't require a lot of money is consulting businesses, which are similar to law firms, right? And law firms also don't require a lot of money. So, what are some common challenges and strategies that you work with clients on when they are starting a low capital intensive business, say a law firm or a consulting firm?
Yeah, so I think that the biggest hurdle, really is the investment amount. So, trying to spend as much as you can on as many, aspects that are relevant to getting the business up and running. Like sometimes prepaying items, prepaying rent, prepaying for marketing expenditures, etc. I think that the other kind of thing with service-oriented businesses is showing the government a track record. So if you do have kind of a successful consulting business in your home country, then showing that track record is going to be helpful. The other kind of thing that's going to be helpful is showing the government contracts or letters of intent, that because they're looking to see that, well, is this person, is it just an idea that they have, or is it something that actually is going to be, viable and ultimately going to be able to hire U.S. workers? The other thing that sometimes it's difficult to do is to actually just hire people, right? So if whenever you're submitting an application for an E-2 and you've already hired a person, that's going to be very, very beneficial for the application. So that's kind of another mechanism that you can do that is very beneficial.
Great. A couple excellent questions have come in over the last couple minutes. The first is about hiring. So, can you say a little bit? You've explained that hiring U.S. workers is a fundamental requirement for an E-2 visa, and if the consular officer is not convinced that the business will hire U.S. workers, you're facing a real chance of denial. And if the officer is convinced that the business will hire US workers, it could be so significant that other aspects of the application, like a lower investment amount, might not be as important. So, can you say more about hiring employees? Specifically, what are ideal employees? Does salary matter? Does it matter if they're
Mhm.
independent contractors? Does it matter if they're US citizens or just, say, non immigrants with work permits? Can you say more about that?
Sure, sure, absolutely. So the hiring workers hiring any worker is beneficial. So whether they're a contractor, whether they're on a visa, whether they're U.S. citizen, green card holder, all of those are beneficial, but they are not equal. So yeah, they're not equal. So let's start with the best in terms of hiring. So the best is a full-time U.S. citizen, right? That's the best, and I'd say that very close to that is a full-time green card holder, right? Now, and the reason this is important because the forms actually ask you to break this out, right? Like if you actually have employees already, you're required to break it out. Even when you're doing the estimate for future employees, you're required to break it out. So U.S. citizen, full-time green card holder, and then we move to part-time employment, but also W-2 employees, right? Like actual employees, and also green card holders or U.S. citizens. So now we move to other types of visas other than E. Right. So someone on another type of visa, you hire them, they're on an H-1B, they're on a TN or whatever type of visa. So other types of visas other than E, that would fall next. And again, full-time, part-time, that would fall next. Then you have visas which are other E-2 visas, right? So people who, like, let's say you have an E-2 employee and things like that. I think those would fall under even the people that are, the people. And in some ways, those can be detrimental to the case because the more E visa employees you have, the more the government's going to see external employment. So maybe we'll take the E employees just kind of off the list for now. Then so now we move to contractors, right? So you have a full-time contractor. Not 100% sure what that is exactly. If they're full-time, then probably they should be an employee. And then part-time contractors as well. So we'll take them. They're going to be beneficial, but definitely employees are going to be better. Now, when we're doing the initial application, though, even though you haven't hired the people yet, we are kind of grouping the people into employees. And if you're doing future projections, you don't know whether they're going to be visas or whatever, so you're going to put them probably in the green card holder or US citizen category. The time this becomes a lot more important is when you go to renew, because then they're looking at who actually is there. Right? So in that instance, we really look, after 5 years of having a visa, you're looking at really having at least the equivalent of 3 full-time employees if you're going to a consulate. It can be less if you're going to renewing through USCIS or extending through USCIS, but you're looking for the equivalent of at least 3 full-time employees. And when I say employees, I mean staff. I think it's always beneficial to have some W-2 employees. But if there were a mix of W-2 and independent contractors, then we could definitely work with that.
Great. Another excellent question came in. We talked before. I had asked about buying a business from a relative. You had explained that situation. A related scenario is what this question is talking about, which is this individual owns an E-2 company along with a U.S. citizen co-owner. Um, and the question is, how can the business partner, the U.S. citizen co-owner, lend the E-2 visa applicant money to invest in the business? This U.S. citizen co-owner will be a passive business partner, and the E-2 visa applicant will be doing all of the work on the business.
Sure. I mean, there's nothing that prohibits it. It's just that and certainly if you did it through USCIS, that's not going to be an issue. As long as you have a valid loan agreement, USCIS will accept it, or should accept it. But if you go to a consulate, you do run the risk of a consular officer thinking that you didn't invest anything, right? That the investment is all this other person, right? And so then you can't be an E2 investor. Maybe you can be an E2 employee, like that, because that might be one way to do it, that someone else has invested and then you become an E2 employee. But it could be that you go and the consular officer feels that you haven't really invested anything because the money's coming from the other business partner. We'd always recommend, if you were getting a loan, to get the loan from someone who is not another owner of the company, to avoid that particular perception. But there's no prohibition in the rules about doing that.
Yeah, it raises a really important observation about the nature of consular officers, which is optics matter, right? Even
Yeah,
if
yeah,
the law doesn't say it's prohibited, if something smells funny, looks funny, there's a chance that the officer won't like it. So that's important to keep
exactly.
in mind. So Ian, the last question I have, and if others, we do have a few more minutes, so attendees, please feel free to send in any last minute questions before we wrap up. Ian, could you just take a step back and share a little bit with us about, at our firm, we do with some regularity have people reach out to us after they've either worked with an outside firm or applied on their own, as you mentioned, and they've been denied. And so our job is to help them identify the weaknesses and strengthen their application and reapply. Can you say a little bit about why E2 visas are denied? What do
Sure.
you see are the key reasons why these visas are denied, and really what are the lessons to be learned from that?
Sure, absolutely. So I think that one primary reason E2 visas are denied has to do with the individual has a business in their own country and has had it for a while and has never hired employees, and now is starting similar or same business in the United States and wants an E2 visa for it. So that's a very big problem. It's one that you can overcome, but it's just difficult to, right? Because it's an officer might think, well, you've been running this business in your own country for many years and you haven't hired employees, so why do you think you're going to be able to do it now? So that can be a problem. Another way, and the reason that's a bad one is because when you're denied for that reason, it's very hard to overcome, right? So it's then, very, very little you can do. The other reason if cases are denied are low investment amount. That's definitely kind of a reason that is big, and in particular depending on your consulate. But that's definitely a reason that can be overcome by spending more money or trying to point to the factors that are more beneficial in your case or positive in your case. The other reason of denial of kind of no fault of the individual is where you apply, unfortunately, right? So there are just some consulates that are very, very difficult. There's one person I remember, he set up a consultation with me, and he was in US for 4 years he did USCIS. And then he went to the consulate in his home country, and he got to the consular interview, and the person said, "What's an E-2 visa?" Right? So it's going downhill from there, right? So it's and and then the officer just denied the case and told him to come back in 2 weeks, and then he then just denied the case. So sometimes, not all consulates are that familiar with E-2 visas, so that's unfortunately a reason as well. And then the final reason is just that the person's not eligible for the E-2 visa. Sometimes it's extreme as they're not from a treaty country, believe it or not. And because there's sometimes people who were from a treaty country, like Ecuador and Bolivia were on the treaty list, but then they were removed, and they're still on the general list, but there's a footnote that says they're no longer, you can't apply. It's just legacy people and things like that, but they apply and they're no longer eligible. So there are extreme cases like that. But then other cases where it might be, a little bit more subtle, like they have seller financing for the majority of their transaction, and they didn't realize that that can't count towards the investment, or other things that maybe make them ineligible, right? So people just that don't understand the rules, and sometimes even at the really unfortunate time this happens is when the person has a lawyer. And not all lawyers specialize in E2. So, but the lawyer just says, "Oh, I'm going to take the case. How hard could it be?" And they're not really familiar with the rules, and as a result of that, send the person to the consulate with bad advice and bad information, and they get denied because of that. So I'd say those are really the key reasons people get denied.
Great. A question came in about E2 dependents,
Mhm.
so children and the spouse of the E2 investor, the principal. And we haven't talked about dependent visas, but you can get an E2 visa as a child or as a spouse of an E2 principal. And this question is a bit nuanced, but it's a great question. So, Ian, if the E2 investor changes status within the US, so they have E2 status in the United States, and presumably the spouse also gets E2 status within the US, meaning so they don't have E2 visas, they have
Mhm.
E2 status within the US. But now the spouse needs to travel, so they'll be going to a consulate. How can that spouse apply for an E2 visa at a consulate? Do they need to bring the entire E2 visa application, or is there a streamlined process for a spouse at a consulate?
Yeah, so I'd say that the safest route would be for the principal applicant just to kind of go to a consulate and get a visa, and for the family to get a visa as well. That would be the safest route. It was this year. So this year, earlier in the year, before March, the Foreign Affairs Manual, which is the manual that governs the adjudication of E-2 visas for consular officers, was changed, and it was changed to indicate that it is fine for the primary to get the E-2 visa change of status, and then for the dependents to get the visa at a consulate. It's explicitly changed in the E-2 visa section. But then um, it was updated. So I actually went to a conference in May, and I was actually speaking at a panel on that conference. And I said something, and I went back later to check the FAM, and I realized that they changed it. They completely removed that section and kind of referred to another general section in the FAM. So there is still a basis in the Foreign Affairs Manual to conclude that the person is eligible, the family members are eligible for a visa at a consulate. But now it's kind of back to the old days before they made the explicit change, where it's rare that that's going to work. I've seen it work before, but it's rare that it's going to work. Rare that a consular officer is going to issue a visa for a family member when the primary doesn't have a visa yet. So the safest route, I think, is to, for the primary to actually go to the consulate with the family to get the visa.
And kind of underlying that response is the fact that consulates aren't obligated to defer to a
Yep.
USCIS approval, right? So
Yep.
even if USCIS approves, many consular officers will
Yep.
not really care,
Yep. Exactly.
unfortunately. And Ian, the second part of the question was, um, I'm going to change it because I think you did answer this, but they mention when you're applying for an E-2 visa and you're within the US. So say, let's assume you're in the US on even a student visa, but you're in the US and you decide to apply for an E-2 visa. Do you need to go to your home country to apply for the visa, or can you apply in Canada? And here, let's assume that the principal is the one applying.
Yeah, yeah. So Canada permits people who are residing in the United States. So not like if you come here just on a B visa or something, but if you're residing in the US, so if you have an F visa or you're in H-1B or L or some other status and you're residing in the US, then Canada does permit third country nationals to apply there.
Perfect. Well, excellent questions to our
Okay.
audience. Thank you for sending those in. Ian, thank you for taking the time and sharing
Thank
your
you.
expertise. So keep an eye out, everyone, for that email. And we do hope to see you on future webinars. Okay, have a great
Perfect.
day.
Great. Thank you very much, Dustin. Thanks, everyone. Bye
Thanks.
bye.